guys, what's up? I hope you guys are doing absolutely fine. Guys, today we will be discussing the very important amendments which is applicable to your examination regards to a subject of corporate and other laws. Guys, this is Viplav Mondal and on behalf of JK Shah classes, today I will be discussing not only the amendments but all the important question which is there in this RTP. Guys, very quickly we'll discuss all the amendments. Guys, you all are very fortunate because we have only 4 to 5 amendments which is applicable to your examination. Very quickly, we'll see all the amendments, and the very first amendment is in chapter number 2. And in chapter number 2, the amendment is in section number 16. Now, what is section number 16? Section number 16 is nothing but rectification of name. So, guys, there's a provision. Very quickly, we'll go and see the provision. So, guys, section number 16 is rectification of name. Now, what is this rectification of name? So, in any case, if ROC allots you a name which the name is already in existence, so guys, central government in suo motu can give you a direction, can pass an order that yes, you have to change your name. Within 3 months, you have to pass an OR and you have to change your name. But guys, it says if you're a registered proprietary of a trademark, that means if I own a trademark, let's take an example, I own the trademark known as Windows. And today, if a new company incorporates in the name of Windows, I have a power to apply to central government, and central government gives direction to that company to change the name within 6 months. So guys, the very first amendment, the time is now 3 months instead of 6. So now government is trying to make both the provision at par. So previously it was 3 months and this was 6. Now I want everyone to make a change and make it to 3 months. Yes, everything remains the same. The next important amendment which comes here, guys. So this is the next inclusion. So before we understand the next inclusion, we'll very quickly come to our JKSC test book, which is page number 42. So I'm just making these changes in page number 42. In any case, if you don't have this material, you can change your own material, whatever material you have with you. Yes, guys, if company does not follow the rules or the directions which has been given by central government, then within the specified period of time, that means within a time. So the previously it was 3 and 6, now it is 3 and 3. So guys, if you don't follow it, previously company and every officer, they have to bear some or the other penalty. So for the company, it was fine of 1000 rupees every day. And for every officer, it was like 5000. For every officer, the fine vary from rupees 5000 to 1 lakh. Now this will be not applicable. So they have deleted this part and they have included a very important amendment, and it says what? So guys, if central government gives you the direction and you don't change the name within 3 months, yes, then in such a case, central government will allot you a new name. Yes, guys, central government will allow you a new name. That means this is a compulsion. Now, if you don't change the name, yes, if you don't change the name within 3 months, central government will allot you a name. And guys, not only that, central government will notify the same to ROC, and ROC will give you the fresh certificate of incorporation. Guys, if you don't like that name, you have to make an alteration in your memorandum by passing special resolution. So this is the next amendment. So it says if company in default in complying with any direction given under subsection 1, central government shall allot a new name to the company in such manner as may be prescribed. Not only that, it also says registrar shall enter new name to the register of companies in place of old name, and fresh certificate will be issued. So guys, this was the basic amendment in your chapter number 2. So the very first changes from 6 months, it is now 3 months. The penalty, the old penalty is now cancelled. Why? Because now the central government is coming up, where central government forcefully will give you a name. If you don't like it, you can for sure change it by filing run form. I hope you remember the full form of run. You have to change your memorandum by passing special resolution. So this was the very first amendment which is applicable to your examination. Let's jump to the next amendment which is applicable to chapter number 8. Guys, this is not a big amendment. This is nothing but they have make an amendment in the rule, and the rule is regard to IEPF. Very quickly we'll revise all the section. This dividend chapter includes section from 123 to 127, and in IPF they have made a small change. Guys, what is IPF? IPF is a special fund established by central government where the unpaid unclaimed account and all the other permissible credits are credited in such account. So let's take an example, application money or matured deposits. All this money will be kept in IPF. So there's an inclusion in rule number 3. So then inclusion. So what is this inclusion? So inclusion is all the shares held by the authority. So now it is which authority? We'll read it and we'll make it very much clear the which authority they're talking about. So authority in accordance with the proviso subsection 9 section 90. So guys, 90 is nothing but 90 is all about SBO. I hope you remember significant beneficiary ownership. Guys, if you don't disclose your name as SBO, tribunal has power to forfeit all your shares. I hope you remember. So guys, this authority is nothing but they are talking about tribunal, that is NCLT in our case. Perfect, guys. So guys, all the shares will be held with the authority. Guys, not only that, all the benefits, let's take an example, all the corporate benefits like dividend, bonus, rights will also be withheld. So this is nothing but an inclusion. Now all the permissible credit, there's a one more inclusion that all the shares and all the benefits from there will be credited to IPF. So there's a new addition in permissible credit. Guys, that's it. This is the next amendment which is applicable to declaration and payment of dividend. There is no change in the section, but they have come up with a change in rule number 3. We'll very quickly make a respective change, or you can just add this line in your JKSC textbook or whatever material you have. You can just write these two statements in your book, right? So that ultimately you have all the amendments in a single paper. Guys, the next amendment is in chapter number 9, which is accounts of company. Guys, this is not an amendment but nothing but a clarification. Clarification in respect of CSR. Guys, I hope you remember the applicable section is section 135 and we have to follow schedule number 7. I hope you remember schedule number 7 includes what all activity will be qualified for CSR. Guys, there's a clarification, and clarification says what? If you are creating health infrastructure, sir, like medical oxygen generation, like storage plant, like manufacturing and supplying of oxygen concentrators, ventilators, cylinder, and any other medical equipments. For what, sir? For countering COVID-19. Then such expenditure shall be eligible for CSR. So this was the very first important, you can say, important change or a clarification. Guys, you can expect a question that, let's take an example, they will give you a case that, let's take an example, the company is spending on such activities, ventilator, cylinder, medical equipments. Will it be used or will it be applicable as per schedule 7? Will it be eligible for deduction? Perfect, guys. So they will be asking such question in the examination. So guys, the next, very quickly we'll jump to the next point. It says, if you are contributing, where sir, into research, development, project, as well as you're contributing, where sir, public funded universities and certain organization engaged in technology, engineering and medical. Again, those activities are eligible for CSR. Very quickly, we'll go to the next important point. It says, company including government company may undertake the activities or project or the program using CSR fund directly or by themselves or in collaboration with shared responsibility with other companies. So it also includes government company can also do this. Guys, very importantly, this clarification is very important. Whenever, so it says whenever you give any benefit, or you can say whenever you give any, you can say COVID-19 vaccination to your employees and families, it is not eligible. It is not eligible for CSR. Whenever you give vaccination, your company gives vaccination to the general society, then in such a case, it will be eligible for CSR. So this was very important. This was very important update, guys. Guys, let's start discussing the very first question which is given to us. This is a MCQ based question, so we'll read it thoroughly. It says, Perfect Tire and Rubber Limited is a listed entity engaged in the business of manufacturing of tires, tubes for light and heavy commercial vehicles. This is not important information for us. During the financial year 1920, the company has declared interim dividend of 5% on equity shares in its board meeting held 17th November 2019 out of the profits earned during the first quarter of FY 1920. Further, the board of directors of the company, after reviewing the results of the fourth quarter FY 1920, again recommended the second interim dividend of 5% on April 2022. Guys, whenever you see such a big case study, my personal recommendation is very quickly see the questions first. So see the questions first so that you already know what are the probable questions you have to answer before reading the case. So we have a question for IEPF, we have a question on interest liability, now we have a question on unpaid unclaimed account, and we have one more question on shareholder cannot increase the rate. So the questions are very simple, but still we'll read the case so that we know what happened actually. So guys, company declared interim dividend twice. Okay, the next important fact is the board of directors of the company approved the financial results for the FY 1920 in the meeting held on 5th of August 2020 and recommended final dividend 15% including the interim dividend paid earlier. So guys, you have to understand, previously twice 5% dividend was declared. Yes, 5% dividend, interim dividend was declared. Guys, what is interim dividend? So guys, final dividend is that dividend which is declared in the AGM, and in between of the financial year, if something is declared, that dividend is nothing but interim dividend. Let us read it. It says, and recommended a final dividend of 15% including interim dividends paid earlier. So that means only 5% they are including. Yes, because already 5 plus 5 it is done. Now the last 5 they are basically announcing in the AGM. So it says, in the board meeting, the general meeting of the shareholder was conveyed on 31st August 2020. So this date is important to me. So they have held their general meeting, that means their AGM. Okay, it says the shareholder of the company demanded, since interim dividend at the rate 10%, 5 plus 5 was declared by the company, so the final dividend should not be less than 20%, including interim dividends. Yes, it says when the company secretary emphasized the final dividend cannot exceed what the board of directors have recommended in their board meeting, some of the shareholders boycotted the meeting and moved out of the meeting hall in the protest of the company's decision. However, the agenda of the declaration of dividend was passed unanimously by the rest of the shareholder present in the meeting hall, fulfilling the criteria requirement of quorum as per Companies Act 2013. So we have one simple question regards to this fact. So we'll very quickly go and read that question. So with the help of this fact, we have a question. It says, when the shareholder demanded an increase in the rate of dividend, but since the shareholder cannot increase the rate of dividend, what the board of directors have recommended, some of them walked out from the meeting hall. What shall be the consequences? So very quickly we'll revise the provision. Guys, whatever the recommendation of board, whatever the recommendation is, shareholder cannot increase that percentage. However, shareholder can accept that percentage. Even shareholder can ask to give less rate of dividend. So guys, so it says what will be the consequence. Let's read it. It says, if even after boycott, quorum is present, it was all the time during the course of general meeting, and they have approved with majority, the rate recommended by board shall be treated as approved. So this is what appropriate answer is. But for the safer side, we'll read all the options which is available to us. Let's read the second option. It says, member present at the beginning of the meeting shall present all the time during general meeting to approve any agenda, else it is treated nullified. So this is totally wrong. It says the approval of the dividend is an ordinary business resolution of a company. So if some of the members are boycotted the meeting, it will have no effect even if quorum is not present. Again, such provisions are not there in Companies Act. The last, it says the recommendation of board of directors of the company relating the rate of dividend shall stand withdrawn. So again, this is not applicable. The right answer is the first one. That is, since it is passed, it is totally passed. Okay. Very quickly, we'll see the dates so that we get to know some other questions. So if you see the questions, guys, so I have a habit of reading question first, all the MCQs first, and then I have a habit of reading the facts. It says, the next question is related to UDA. At which date the unpaid dividend not claimed by the shareholder shall be transferred to the separate bank account. So guys, I hope you know about UDA. UDA means unpaid dividend account. So whenever company declares any dividend, within 30 days they have to transfer it to the shareholder, and if they don't transfer it within that said 30 days, then after the expiry of 30 days, within 7 days they have to transfer it to UDA, that is unpaid dividend account. So if I draw a very simple timeline, it says if today AGM has held, then we have 30 days, and after 30 days you have to transfer all the dividend, and after the completion of 30 days, if something remains with us, within 7 days we'll open a new account, that is unpaid dividend account, unpaid unclaimed dividend account. We'll transfer the same to that account. So very quickly we'll calculate the dates. So very quickly we'll see the dates, because the dates are very important here. So the meeting was held on 31st of August. If you see, so 31st of August, the AGM was held. So I will write here itself so that you can also have a clear picture about it. So 31st August is the date when they have held their AGM. Perfect. Within 30 days. Yes, within 30 days. From August, it is September. After 30 days, it is 30th of September. 30 days completes. Okay. And it says what shall be the date? So what's the question? Let's go and read it. So it says shall be transferred to separate account in the above case. So whatever the unpaid dividend is, that within how many days you have to transfer? So you have to transfer it within the 7 days after completion of 30th of September. So guys, the appropriate answer is 7th of October. How, sir? So guys, you have to just go here and see here. Come on. It says completion of 30 days. Within 7 days, you will open an UDA account, that is unpaid unclaimed dividend account. So if you count it, it will come to October 7. So the appropriate answer is within 7 days from the date of expiry of 30 days. So D is the correct answer. So we have successfully solved 2 questions, but very quickly we'll see the case again. So we have a question on, in the given case, when and how much amount the company shall transfer the fund to the Investor Education Protection Fund. So guys, if you see in the question, we have a schedule. We have a schedule, and which includes the whole important, you can see the series here. So guys, the rule is very simple. As per section 124, if in the unpaid unclaimed account, that is UDA account, if it is there for 7 long years, then after 7 years, we have to transfer that money to Investor Education Protection Fund. This is the rule. So guys, the timeline is very simple. If today is our AGM, within 5 days, we'll open a new bank account and we'll transfer all the amount which is payable. Within 30 days, we'll transfer all the money. If something is with us, within 7 days, we'll open a bank account, that is UDA account, and we'll wait for how many years? 7 years. After completion of 7 years, we'll transfer that fund to Investor Education Protection Fund. Yes, so we have a nice data. So guys, we have to understand the date. It is, since we are in the year 2022, but guys, the question is of 15th October 2020. So guys, here you can understand that we are in the year 2020. So we have to think as per 2020 and not 2022. So guys, very quickly we'll see and we'll read this also. But guys, let's go and solve that question and we'll read that case again. Okay, it says what? It says company transfer the amount of unpaid in the separate account on 15th October. It says on 15th October. It says the company transfer unpaid dividend in separate account on 15th October. So guys, I hope you can see a violation. Yes, we have a violation. That is, you have to transfer it within 7 days. So guys, if you track the days, it is 7th October. You have to transfer it. But since you have did work on 15th of October, that means you are late. And as per the provisions, it says the penalty is 12%. So answer will be C, not 10, no liability, and 15 is not the valid answer. Again, if you see, we have successfully solved the 3 questions, and we'll read the next case also. And the next case is, in the given case, when and how much amount that shall be transferred to Investor Education Protection Fund. So the law is 7 years. So 6 years will not, 5 years will not applicable for the 7 years is, that is 8/7/2013. Even if you see the schedule, you will get to know that. Even if you see the schedule. So you can see, this is the latest, guys. This is all the latest. So after completion of 7 years, you have to transfer it to Investor Education Protection Fund. So the reason is the 7th year, that is after completion of 7th year, option D is the appropriate answer, guys. Okay, so guys, you can see we have successfully solved all the question, and we have not yet read this paragraph, and also we have not read this paragraph, but still we have completed. However, I will read this paragraph for you because it says there's a delay. We'll read it. After approval of shareholder, the dividend was paid to the shareholder. However, dividend to some of the shareholder could not be paid within the prescribed period, that is 30 days. The company transferred the unpaid dividend to the separate bank account on 15th October. It's a violation, and that successfully I have basically discussed that. Again, this is, we have no question to this fact, so you can just pause this video and can read it. However, we don't have any question. So this was a very simple question. If you know the concept related to dividend and from section 123 to 127, if you know these section, automatically you will able to solve all the question even if you don't read the story. However, we have to see the facts. That is very important. My kind suggestion will be just have a quick reading about the question, so that whenever you are reading the facts, you already know the question what they are already asking us, so that for marking the answers it will be very quick and very simple. Okay, so we'll jump to the next important question, the next MCQ, and it says what? It says Amber Limited is a manufacturer of glassware. Its paid up capital is divided into 2 lakh shares of 100 each. The company is maintaining its register of member as per the provision of Companies Act 2013. Company wanted to close its register of members for declaring dividend. It may do so by giving minimum dash days of notice. So whenever you read such question related to closure of books, the very first section number which should come to your mind is section number 91. And what is 91? 91 says that yes, you can close your book for a year. The maximum limit is 45 days in a financial year, but at a stretch, at once, you can close maximum 30 days. So they have not asked that. However, they have asked if you want to close your books, it says minimum number of days notice, so that you have to intimate to the public first and then you will close the books. So it says if you're closing books today, law says 7 days before you have to give the notice. The answer is first 7 days. Very simple, guys. We'll jump to the next question, that is the third question. And it says what? Dash interpretation concerns itself with what the law says, and interpretation seeks to ascertain what the law means. So guys, very quickly, the options are grammatical, logical, legal, usual, usual, legal, logical, grammatical. So guys, very quickly we'll quickly revise the concept so that you just recall everything. So guys, whenever we do the interpretation, so we have doctrinal interpretation. It says what? We have two types. The very first is the grammatical and the second is the logical. The very first instance is that we'll try to understand, we'll read it in a plain language and we'll understand what the lawmakers or draftman wants to convey us. The next is, the next interpretation says, if we don't understand in such a way, we'll use the logic of the draftsman. So guys, the very simple, the correct answer is A, that is grammatical and logical. Again, it was very easy question. We'll very quickly go and discuss the next question, that is fourth question. Let's read it. It says, Arvind lends money to Mamta. So whenever I see a case-based question, so we'll quickly draw a diagram. So Arvind lends money, gives loan to Mamta. Yes, again the security of jewelry. So Mamta gives security, jewelry. So Mamta is pawner and Arvind is pawnee, because who gives the security becomes the pawner. It says what? It says Arvind gave his jewelry to his friend Vinayak, who is having a safe locker at his home. So basically, Arvind gave the same to Vinayak. Perfect. So the question is, who is spawner? So it's a very simple question. The option will be B, Mamta. That is, while solving the question only, we already know the answer was Mamta, because the question says who is the spawner. A very simple question. We'll quickly jump to the next question. That is the fifth question. And the question is, it says, Raman, the original allottee of 2000 equity shares in ABC Limited, has transferred the same to Ruchi. The instrument of transfer dated 21st August 2020, duly stamped and signed by Raman, was handed over to Ruchi. The question is, advise Ruchi regarding to the latest date by which the instrument of transfer along with the share certificate must be delivered to the company to register a transfer in its register of members. So law is very simple. So guys, the relevant section is, that is section number 56, which says after completing all the formalities, you have 60 days to submit it to the company, and company will register the same. So guys, if we see the date is 21st August. So from August to September, September to October. The correct answer is October, and since all the question doesn't match the October, it is very simple. It was 20th October 2020. We'll count it from 21st of August. So this was a very simple question. With this, we have completed all the MCQ based question. We'll move to the part B question, and let's solve all these questions. So part A, all the MCQs are done. Very quickly we'll jump to the descriptive question. So what kind of questions they have asked? Very quickly we'll read the very first question. And the very first question to the descriptive part is, it says, the following are the some securities issued by different companies related to each other as follows. So we have different companies. So for simplification, we'll call it as K Limited, I Limited, S Limited. Perfect. It says K Limited. It says they have issued securities. It is listed non-convertible redeemable preference shares and issued on private placement basis in terms of SEBI regulation. Okay. I Limited listed non-convertible debt securities issued on private placement basis in the terms of relevant SEBI regulation. Okay. So these are nothing but they have issued some securities. The next importance is S Limited issued non-convertible debt securities issued on private placement basis in terms of SEBI regulation. Great. It says we have some remarks to it. It says has power to appoint 2/3 of I Limited. So K Limited can appoint 2/3 of BOD. So okay, this information will be used for subsidiary company if they ask a relationship. It says holding 60% of voting right of S Limited. Okay, so I Limited is holding 60% of voting rights. Okay, and it says the company, that is S Limited, holds 52% shares in P Limited as an investment on behalf of other company in capacity of trustee. Very important. Now let's read the question and let's see. It says the equity shares issued by K Limited and I Limited are not listed in any recognized stock exchange. Great. It says in the context of aforesaid facts, answer the following question. And the question is whether the aforesaid company can be considered as listed companies. So guys, very simple. They are asking us is the company is listed or not. So very quickly we have to see the definition of listed company. So if we see the answer, so guys, it says according to section 252. So what is this 252? This is nothing but the definition of listed company. So guys, listed company means a company whose securities are listed in any recognized stock exchange. Guys, however, you have to understand that a very important thing, that we had an amendment very recently where it says if a company whose shares are not listed, but it says that they have non-convertible debt securities or non-convertible redeemable preference shares, yes, as per SEBI regulation, as per SEBI regulation, as per SEBI regulation. I hope you can see that. It says even if you are not having any shares, but you have non-convertible debentures or non-convertible debt securities, non-convertible redeemable preference shares, which are listed in the recognized stock exchange, still, you will be not considered as a listed company. So guys, the question was very simple. They ask what is the status of the company. So very quickly, K Limited did a private placement, even if their debentures or the preference shares were listed, convertible preference shares were listed, still they will be not considered as a listed company. So this is absolutely right. I Limited, again they issued some instruments and which is debt securities, still they will be not considered as listed company. Sir, why? Because definition has a clarification regards to that. And since S Limited is a private limited, it will be not considered a listed company, because the very important definition of listed company is that you have to be a public company. So private company anyways, they cannot be a listed company. And also, even if they are issuing some instrument of non-debt securities, still you will be not considered as a listed company. Okay, the next important question what they are asked is, explain the relationship between of the aforesaid company. I hope you can see K is holding company of I is holding company of S. I hope you know the basic definition of holding subsidiary. I hope you know that a holding has a power to control or to appoint the majority of the BOD of the subsidiary. And if you are holding more than 50% of voting rights, again, wherever you're holding that company, wherever you're holding any shares, that company becomes subsidiary company. So very quickly we'll see that as well. So it says 246 and 287 holding subsidiaries definition. So if you have a power to control the composition of BOD, also you have a power, or you're holding more than one half of the voting rights, or either guys, either of one is satisfied, then in such a case you're a holding company, and wherever you're holding such shares or such powers, that is a subsidiary company. So rightly said that the relationship. So K Limited, I Limited, what is the relationship? The relationship of holding subsidiary. If you say I and S, again holding subsidiary. If you say K and S, again holding subsidiary. But I have a basic question to you all. Sir, what about S Limited is holding some shares to P Limited, 52%. Will it be considered as subsidiary? The loss is no. Why? Guys need to understand, if you're holding shares on trust basis, you're not the real owner. Even if you're holding above the limit, still you will be not considered as a holding company. This was a very important question. I hope you can see, and we have a clarification here. Says on 27 December 2013, MCA clarified that. And what they have clarified? They have clarified that if you're holding any share, which having any power, yes, on the fiduciary capacity, guys, you will be not, or the, even if you're holding above the limit, you will be not called as holding subsidiary. The relationship will not come into existence. So this was a very simple question. Let's move to the next question, and let's read the question. It says A Limited, having 1000 members with paid up capital of 1 crore, decided to hold AGM on 21st August 2022. So we'll highlight the date. Okay, it says, and it received a notice on 2nd July 2022 from its 60 members holding paid up capital of 7 lakh in aggregate for a resolution to be passed at the AGM appointing V and Company as its auditor from FY 2023 onwards, instead of existing auditor C and Company, which was originally appointed for 5 years and they have completed its 4th year. So they want to remove C and Company, and they want to appoint V and Company as a new auditor. It says such notice of resolution was forthwith sent to the company, to CN Company, which gave its representation in writing to the company along with the request for this notification to the members of the company. But it received too late, 3 days before the meeting of the company. So, what the question is whether the said notice was given by adequate number of members. So the question was that 7 lakh rupees, they're holding paid up capital of 7 lakh rupees. We'll see the provisions as well. Second important question is whether the company was bound to send its member such a representation made by C and company. And if it could not be sent, then in such a case, what shall be the responsibility? So, very simple question again. Very simple question. If you want to answer this question, you should know the meetings chapter and also the auditors chapter. Come on, very quickly, we'll see the answer. Come on, it says 140, section 144 says of Company Act 2013 that, guys, if you want to pass anything or if you want to remove anything, so guys, you have a power. It says at least you should hold 1% of total voting power or shares which aggregating or not exceeding 5 lakh rupees. So guys, they are not holding 1%. So the question was, it says give the adequate number. Do we have the adequate number? And the law says they should not hold less than 1. Yes, so we have that the provision doesn't satisfy, but it's a or holding shares on such aggregate sum not exceeding 5 lakh rupees. Since they are holding more than 5 lakh, so they are allowed to give the notice. The very first question, yes, we have an adequate number. Since there's an explanation, you can see here, since 1000 member and the capital is 1 crore, if and from the 60 members they have received and the capital is 7 lakh, paid up capital is 7 lakh, and the law says it should be more than 5 lakh. They are holding more than 5 lakh because their aggregate is you can say 7 lakh. They are allowed. We have minimum the number which has been prescribed, that we have adequate number. So this is very simple. Next question was the representation which has been sent by the auditor's firm, that you have to send it to your member. So guys, you guys need to understand, is it, if it is not happened, so within how many days we have to do it? So the law is very simple. It says the notice shall it be sent within earlier of 3 months but at least 14 days before the meeting. So the date was very simple, 21st August 2022, and the notice is given on 2nd July 2022, again which is in the prescribed limit. Yes, so if you see the notice was given on the meeting was on 21st of August, and they have given the notice on 2nd July. So ultimately it is more than 14 days, so ultimately the time is also prescribed. Again, a very simple question, but very quickly we'll see about what about the notice, if that the contention of the firm, that again you have to send it to the members. So since they have received the contention from the firm very late, guys, what you can do, the very simple thing what you can do, you can just read out in the meeting, that is also there. So very quickly you can see here, you have a right to heard orally. Yes, CNP just make a representation in the AGM, so they can read aloud in the meeting and they can very quickly just solve this matter. Yes, so they can put up their representation in the meeting itself also. So again, the second question, you should know two important chapters. First is the meeting chapter, second is the auditors chapter. Okay, the next important question, let's move to the next question. It says Vrinda Limited is a company manufacturing orange and strawberries candies for kids. Now the company wants to expand its business and start a manufacturing of 10 more type of candies. Okay, great. The company has raised 1 crore to the issue of non-convertible debentures, not constituting a charge on the asset of the company. So they have not created charge. So charge is 216 of the company and listed on the recognized stock exchange as per the applicable regulation made by SEBI. Advise whether the amount of 1 crore will be considered as deposit or not. So you should know the basic definition of deposit and what is not deposit. So we have a huge list. So even if you know the basic rule, that is 21C, what is not deposit, very quickly you would have said the answer. It is obvious, it is no, it is not deposit, but still we see the answer. It says as per sub-regulation 21C, that is the rule of companies acceptance of deposit rules 2014. We have n number of it. So the list was very huge, and it says the amount raised by the issue of non-convertible debenture not constituting a charge on the asset of the company and listed on recognized stock exchange as per the applicable regulation. As per the applicable regulation, shall not be considered as deposits. As given in the question, it shall not considered as a deposit. It was a very simple question, very simple question. Let's go and discuss the next question. It says, the BOD of Plum Limited proposes to issue a prospectus inviting offer from the public for subscribing of the equity shares. Okay, so they are basically asking us question from the prospectus chapter. State the report which shall be included in the prospectus for the purpose of providing financial information under the provision of Companies Act 2013. So it was again a very simple question because it asked the relevant section is section number 26. It says basic things. 26 says what are the content of prospectus. So very simply, you can just see what needs to be included. So guys, every prospectus, it should include some basic things. Financial information, it shall be date, signed, yes, and you have to issue as per the SEBI rules in consultation with central government. Again, you have to make sure that some basic things need to be there, some basic things, some basic rules should be some basic rules should be followed. Not only that, we have to follow only SEBI regulation, but yes, all the applicable provision. We have to follow SCRA, we have to follow ICDR. These all are SEBI regulation which is applicable. So this question was again very simple and straight away question. Yes, it says you have to follow Companies Act, you have to follow SCRA. You can see you have to follow SCRA. So these are the rules and regulation you have to follow if you're planning to propose your IPO. So guys, it was very simple question. Yes, you have to follow all the securities law and you have to include all the basic documents as per all the basic reports from the expert as per SEBI. The next important question is, one of the matter contained in the AOA of D Foundation, that is Demand Foundation, incorporated as limited company under Section 8. So it's a NGO, Section 8 company of Companies Act 2013 was altered by passing a special resolution in its general meeting, and thereafter intimation for the same was given to ROC. So guys, the very simple thing is that they have altered and they've informed to ROC. The basic rulings of Section 8 company, you have to take approval of central government first and then you can make an alteration. However, let's read the question. However, such alteration in the article were opposed by Dodge and Company, a partnership firm which is a member of such, and of such alteration was not valid. Advised as per Company Act 2013 whether the contention of Dodge and Company was valid. It is obvious it is valid. Yes, but the change what NGO did, it is not valid. Why? The contention, you can say the allegation what this partnership firm is doing, it is absolutely perfect. Whatever the task this NGO did, it is not perfect. Why? For an alteration, you have to ask, you have to put up a permission, get a permission of central government. They have not did that. They have straight away did the alteration and inform it to ROC. So let's read what's the answer is. So the very simple, it says, according to Section 8 of Companies Act 2013, and you have to see, you have to take an approval of central government. You have not taken any approval, guys. So guys, so you can see that yes, we have a problem. So the problem was absolutely pointed out by this partnership firm, and there's a faulty, you can say, alteration. So here one of the matter of the articles of D Foundation was altered by passing special resolution in its AGM and intimated to ROC. So guys, you need to understand, as per the act, it is necessary to take prior approval to ROC for the same, and it is not done for the present case. The contention of the Gen company was valid. So by just reading the question, I have said you the answer. However, let's read the next important question. Mr. Abhi is a chartered accountant and MBA. Wow, double combination. Has been appointed to an executive director of the board of XYZ Limited. His job profile include advising the board of directors on various compliances matter, strategies, business plans, risk matters, and keeping in view of the above position, whether Mr. Abhi can be classified as a promoter of XYZ Limited, and please examine the same under the provision of Companies Act 2013. The answer is obvious no. If someone is giving services on professional capacity, they shall not be considered as a promoter. However, let's go and very quickly see the applicable provision is 269. It defines the basic definition of promoter. It says if your name is in the annual report or annual return, or you have classified as a promoter and the name is been included in the prospectus, you're a promoter. If you can directly, indirectly control the company, you're a promoter. By your advice, the BOD is accustomed to act, you're a promoter. However, in the given case, you have to understand that Mr. Abhi is giving the advice on professional capacity. So Abhi will be not classified as a promoter, guys. Yes, Abhi will not be classified as a promoter. Guys, you need to understand that whenever you will be answering any case law question, make sure you divide your answer into three parts. First, write the provision of the act. Second, discuss the case study. And third, give the conclusion. Right? So let's read the seventh question. It says what? Krish Limited created a charge on its asset on 2nd Feb 2021. However, a company did not register the charge with the register of companies till 15th of March. Rule says within 30 days you have to register. However, let's see the question. What procedure should company follow to get the charge registered? They have to file CHG1 or CHG9 in case of debentures. In case of debentures, you have to file CHG9, or else the basic rule is CHG1. Let's see. Suppose the company realizes it's a mistake and not registering the charge on 27th of May 2021 instead of 15th of March. Can still they register the charge? Advise with the reference of the provision. So the relevant section is charge, that is definitions 216, and the relevant section is 77 section. So guys, very quickly we'll see the chart, we'll see the diagram, how it works. So here's the chart. Guys, here's the chart. So our question is very simple. The date is on 2021 and we have basically two charts, and it says before 2nd November 2018. So this is not applicable in our case. The applicability is on or after 2nd November 2018. So what is the basic, you can say the flow chart is, you have to register within 30 days to do that, and if not done in 30 days, you will get additional 30 days, and still if you don't do that, ultimately you have to pay ad valorem fees and ultimately you have to register. If you are late, if you come after 30 days, anyways you have to pay additional fees. So guys, let's go and let's see the answer. So very simply they are just telling us, okay, section 77 1 is applicable and it is the duty of the company to register their charge within 30 days of creation. So not only that, if you have to complete the registration within 30 days, if you don't do it, you have to pay an additional fees. Still if you don't do it, you have to pay an additional ad valorem fees. So ad valorem fees, they have a schedule. I will show you that also. So we have a schedule just to understand. They will not ask in the examination. You can see what is how it works. So there's a step 30 plus 30 plus 60, then additional fees, then you can see then ad valorem fees. So the very simple thing, if you come after all the expiry of 60 days, then ultimately you have to pay the ad valorem fees. Yes, so this is just only for your understanding. Okay, so guys, I need to understand that if you come late, you have to pay ad valorem fees. Yes, so if you have to register within 30 days. If you come late after 30 days, additional fees. Even still you come after like after 60 days, then you have to pay additional, that is ad valorem fees. This is how it works. Additional fees plus ad valorem fees. Yes, so you have such a big timeline. If you don't follow it, guys, you just have to pay additional fees. Okay, so this is what you have to file the form, that is CHG1 or CHG9 in case of debentures. and with that you have to give all the certificates, documents which is applicable. You have to give all the certificates and documents. So that is very important. So within 30 days you have to create the charge. If you don't create the charge, you will get next 30 days to create it. That means within 60 days from the creation, you have to pay it with additional fees. But if you don't do it even after 60 days, then guys, you have to pay with additional plus ad valorem fees. This is very, very important. Come on. It says if you do it late. So the question says if you realize it, they're doing it after 27th May instead of 15th. They are planning to do it on 15th of March. So guys, they have to pay ad valorem fee. So if you see the dates, so creation of charges 2nd of Feb. So they have to do it within March. However, they are doing it on 15th. They have to pay additional fees. And if they are doing on 27th of May, they have to pay ad valorem fees. So this is what the question was. So very quickly, we'll go to the 8th question, the last question of corporate law. It says Vishal Limited has a paid dividend every year at the rate of 10% on its equity share capital at least last 5 years from 15 to 16 to 1920. So the company is consistently paying the dividend at the rate of 10%. Company has incurred losses in the current financial year, that is 2021, and still want to give dividend. Whether company can do so? Very simple and straightaway question. They're asking about rule 3. Yes, rule 3. Yes, they are asking about rule 3. Rule 3 of what, so? That is company's declaration and payment of dividend rules 2014 are very simple, that we have some condition that you have to take an average of last 3 years. It should not be more than your average. If company has not declared in last 3 years, then the first provision will not apply. Then it says it shall not be more than 10%, and after using all the reserve, the last, you can say, after withdrawal, your reserve should not be less than 15% of paid up share capital. So this is what, this is a direct question what they have asked. So even if you don't have profits, no worries guys, you have to just follow rule 3 and still you can declare the dividend. So these were the 8 questions related to corporate law, and the next question is related to other law, which includes the Negotiable and Indian Contract Act, all the parts. So just now we have just completed all the questions, all the MCQs. Now we'll start with the next important question related to Indian Contract Act, the 9th question. The next question is the 9th question and says what? Surendra. So just for the ease of reading, I will just mark it as S. Okay, so I will, for the whole discussion, I will say it as S. Okay, so it's Surendra guarantees Virendra, that is V, for the transaction to be done between Virendra and Jitendra. So you can see there's a concept related to the guarantee. So S guarantees V that whatever the transaction V and J will do, S will basically act as a surety. During the month of March 2021, we supplied goods worth rupees 30,000 on 1st March 2021 and of 20,000 on 3rd March 2021 to J. On 5th March 2021, S died in road accident. Okay, sad. On 10th March 2021, being ignorant about the death of S, Virendra further supplied the goods of 40,000. So we have two transactions. First is 30k, second is 20k, and third is 40k, but after death. Okay. On the default made by Jitendra on due date, Virendra sued the legal heir of Surendra, that is the surety, for recovery of 90,000. Describe whether the legal heir of S, that is Surendra, is liable to pay 90. So guys, very quickly, we should know that discharge of continuing guarantee. Guys, I hope you already know in case of revocation, guys, it can be revoked by surety, or in case of death of surety, the guarantee automatically revokes. However, any guarantee or any transaction before the death will be liable from the estate of the guarantor or surety. However, after the death, if something happens, any transaction, the private estate or the legal heir shall not be responsible. So very quickly we'll see the simple provision. The applicable section is 131. It is related to continuing guarantee. Very important, very important. Every year they ask question on continuing guarantee. Yes. Okay. So the very simple, what question they have asked, we'll read that as well. We have one more question. It says, what would be your answer if estate of surrender was worth rupees 45? So the estate is worth rupees 45, ultimate at the end. So guys, the very simple thing is that the very first two transaction, that is 20k and 30k transaction, the legal heir or the estate will be responsible. After the death, the legal heir or the private estate of the deceased person shall not be held liable. So guys, need to understand that on the above cases, yes, you can see all the transactions, that is of the 50k, like 20 and 30, the Surendra's legal heir will be held liable. Yes, held liable. So guys, need to understand. It says continuing guarantee is revoked by the death of the surety as to the future transaction. The estate of deceased surety, however, liable to those transactions which has already taken place. So already taken place is 20 and 30 during the lifetime of deceased. Surety's estate is not be liable for the transaction after the death of surety. So very simple. So 50,000 will be held responsible, and the transaction happened after the death, there will be no liability on it. Now the question says, what if the estate worth rupees is only 45? In that case, since the amount receivable was 50,000, but we can only claim 45, and the rest 5 rupees of the rest 5,000 shall be obvious treated as debt, bad debt. However, you can recover it. Come on. The next important question, the question is related to Negotiable Instrument Act 1881. It says Anjum drew a check of 20,000 payable to Bablu and delivered it to him. Bablu endorsed the check in favor of Rehansh R and kept it on the but kept it in his table drawer. Subsequently, Bablu died. So sad. And check was found by Rehansh in Bablu's table. Yes, that is the somehow Rehansh found it. Rehansh filed a suit of recovery of check, whether Rehansh can recover the check under the provision of Negotiable Instrument Act 1881. So again, there's a sad story. Very quickly, we'll decode the story. So Anjum basically drew a check to Bablu. Yes. And Bablu also endorsed it to the Rehansh, but not delivered, guys. Not delivered. But somehow Rehansh came to know about it, and Rehansh directly went to Anjum and filed a suit against it. So the question is, can Rehansh recover the amount of check from Anjum? Answer is no. Why? Since guys, you need to understand this is an order instrument. And for order instrument, the condition of endorsement is you have to write the endorsement, you have to sign, plus you have to deliver. Since Bablu didn't deliver the instrument to Rehansh, there is no valid endorsement. Hence, Bablu or Rehansh will not able to recover the amount from Anjum. So see, very quickly we'll see. It says Section 48 of Negotiable Instrument Act 1881 says what? A promissory note, a bills of exchange, check payable to order is negotiable by the holder, yes, by endorsement and delivery. You have to write it, sign it, and you have to give it. So ultimately, it's not done, guys. Delivery was not done. So, however, in this case, in this case, there was no delivery. Ultimate endorsement was flawed, and Rehanj will not able to claim the amount of check. So they have just discussed. You have to see whenever you see a case study question, please make it a habit that please divide it into 3 or 4 paragraphs where the provision, then the case, and then the conclusion. Perfect, guys. Now let's go and let's discuss the next important question. It says the General Clauses Act 1897 says Ayush and Vipul are two good friends pursuing CA course while doing group studies for the paper of corporate law and other law. That means even they are viewing this video. They were confused. Wow. About the provision of Section 3 of Companies Act. It says a company may be formed for any legal or any lawful purpose. Both Ayush and Vipul are in difficulty about the meaning of word may, whether it should be taken as mandatory or directory. So guys, need to understand, we have to explain two important words. Shall, which is basically, you can say, the word where we use it as a compulsion. You have to do it. Yes. Whenever I say may, it is not mandatory. So guys, shall is kind of something which is mandatory. You can interpret it in that way. But may is which is not mandatory. But sometimes you got to need to understand may and shall. We use this interchangeably and see what was the intention of the draftsman. So guys, as per section 3 it says may, company may formed for any lawful purpose. It is obvious, lawful, it is obvious the draftsman will never ever allow company to be formed for any unlawful object. So guys, you need to understand here the use of may shall be read as shall. Yes, to make it mandatory for the company for the compliance of section 3 in its formation. Why? Because never ever draftsman or anybody will not allow anyone to form a company with unlawful object. Perfect, guys. Come on, very quickly we'll see the last question. What is this last question? A direct question, and it is obvious the majority of times we get the direct question from the interpretation of statutes. It says, when can the preamble be used as an aid for interpretation of statutes? So guys, you already know it's a direct question. Guys, preamble are generally used as to know the aims and objective of the law. Whenever there's a conflict between preamble and the section, section will always prevail, provision will always prevail. So guys, we need to understand preamble. Preamble is basically, you just need to understand where there isn't any ambiguity in the words, in the legal phrases. Then in such a case, we'll read the preamble just to know about, okay, what was the basic intention. Yes, where the words of an enactment appear to be general in scope or application, then court may resort to preamble. So whenever you get confused, what is this word, what is this statement? We'll go, we'll read the preamble, we'll get an idea why we have formed such rules and regulation. So guys, this was the end of this discussion, guys. I hope somehow I have cleared, I have revised all the questions. If you have any doubt, please put it in the comment box so that I can very quickly resolve your queries. Do like it and share it with your friends who are planning or who are giving this examination May 2022. All the best and stay tuned for awesome lessons. Bye-bye.